afternoon to all of you. We're starting the Tuesday meeting of the House Judiciary Committee, and I know we got some bad weather, so we'll try and expedite as much as I can our hearings today. And one of the first things I want to do is Ms. Braddock here. Ms. Braddock, you have someone you wanted to have address the committee from out of town, and I would be honored to have you come forward with your guest and introduce the person. This deals not with the bill that we have today, but it does deal with House Bill 794, which is referred to as the compact bill. And you have a copy in your file of some information regarding this particular legislation. I don't know if a copy of the bill's in here or not, but we put several documents that have been furnished to me as a part of the consideration. There is a copy of the bill, so you might want to look at the literature as well as follow along with the statements of our guest. And Ms. Braddock, if you would introduce your guest.
Thank you, Mr. Chairman. I appreciate y'all being here. I know the weather's bad and y'all want to get home. Nick Tronius is here from Arizona with the Goldwater Institute, and he's flying out in the morning. So I appreciate y'all hearing this, and I'm going to let him have the floor.
Well, Mr. Chairman, members of the committee, thank you so much for staying and allowing me this opportunity to present. Let me just briefly explain who I am, what my background is, really briefly, and then walk you through the submissions, if I may. First of all, I'm a 16-year practicing attorney. The past 8 years have been focused in constitutional law. Not to brag, but to give context, my main claim to fame is having gone to the U.S. Supreme Court and successfully had Arizona's clean election system struck down in substantial part. We got rid of the so-called matching funds provision of the system that was in place. Leading into that, I used a ancient writ called the All Writs Act to actually get Justice Kennedy to intervene and block the system even before they took cert, and that's only happened about 6 times in civil practice. So that's some background. On the Article 5 issue, I commissioned in 2010 Rob Nadelson's famous now among think tank circles 3-part series on the state origination of amendments. I commissioned him because he was way ahead of me, and I was about to do my own, and he said, hey, just commission me, and we're done. And so we did. And so I'm proud to say that on the Article 5 issue, I've been engaged before it was cool, and into much frustration, because until we saw the latest spark of real engagement from the popularized folks on the center right, it seemed to be quite a quest. We're fortunate now to have many people on the left and the right and in the center that are engaged on this issue, and it's moving forward in an entirely new way. And with that said, let me just identify what's before you in terms of written materials and then go into a PowerPoint presentation. Let me warn you, I do not have a computer or a projector. I am doing a manual PowerPoint presentation.
Yeah, we have a copy in our file. So
that's correct, Mr. Chairman. And if you're looking for it, it's the document that is starts with the testimony of Dr. Kevin Gutzman.
Everybody have a copy of this? If you don't, you do? Do you have do you need any extra copies run off? I don't want to slow us down too much, but if you can, maybe look on together if you don't have it. Look on with your associate there. Thank you. All right. Maybe some more in the files here. We don't. I think we got some copies here, Mr. Gutzman, so we'll get those pulled out and distributed if we can.
Judge is used to attorneys bringing them stuff up.
Yeah,
Go ahead, start.
All right.
Including his coffee.
May I approach the bench?
All right. Mr. Chairman, members of the committee, if everyone has at least a visible copy of the PowerPoint, it is the first page. It says states fix the debt. Now let me just briefly indicate we have some written testimony attached. You can read the details later, I suppose. But what's important to highlight is who is supporting this effort among the experts that we've marshaled. Dr. Kevin Gutzman, professor of history, New York Times bestseller, has written testimony in support of this effort. Dr. Sven Larson, the rare center-right Keynesian economist in the think tank world. He has endorsed the compact approach. Attorney Ilya Shapiro, Cato Institute's main constitutional scholar, who's authored hundreds of amicus briefs at the Supreme Court. He's endorsed the compact. Harold DeMoss, the CEO of Compact for America, of course, endorses it, but also his father on the advisory council, a senior judge at the Fifth Circuit Court of Appeals, U.S. Circuit, has also had a part in developing and endorses the compact as fully constitutional and indeed timely. So in addition to that, you have a number of fact sheets. The most important thing about the fact sheets is that I'll be able to field any questions you might have, and whatever I don't cover will be covered in them. But if you really feel like getting into the weeds of the law and the policy, probably what's called using a compact for Article 5 amendments.
That's in our files too.
That should be, thank you, Mr. Chairman, that should be the place, the go-to place. We have listed in there the 12 most common questions we have received from experts, scholars, peer reviewers, legislative counsel, and we've provided detailed, extensive legal analysis. And when I say we, I mean Dr. Gutzman, Judge DeMoss, a gentleman named Shane Atwell, who's a director of a constitutional academy, myself, and Ilya Shapiro at Cato Institute. We all collaborated on this together. And with that said, if we could go to the first page of the actual part of the PowerPoint presentation. Now, what I always like to do is center the discussion on what the problem is, because, you know, why waste our time on legislation if we don't have a defined problem? This is an actual chart. This exponential growth chart is an actual chart of what is happening to our gross federal debt. This is the precise example of something that's unsustainable. It is rocketing out of control. This is a broken system. Now, some folks might say that this is only nominal, it doesn't adjust for inflation. I suggest we go to the next page. I think what is more important than looking at inflation adjustment is how much of our economy is encumbered by debt. If you look at this chart, over 100% of our GDP, everything we produce in this country in a year, is encumbered by debt. And we have not been in this place since the darkest hours of World War II. And just in case you think we can grow out of this like we did in the 1950s, remember, we're not the only economy standing right now, and we're not going to be. And on top of that, we've already mortgaged quite a bit of our future, because estimates range between $50 trillion and $222 trillion in unfunded entitlement programs. So we are in a fundamentally unsustainable, calamitous state with our debt. This is an emergency. It requires rapid action. It requires leadership, and we're not getting it from Washington, and we're not getting it from either party. We're going to have to look to the states, and we're going to have to look to everyone of both parties. And just in case you have heard the news that everything's going well, that the deficit's turning around, just look at how little the deficit has closed in the next sheet. This is not a meaningful improvement. This is still calamity on the horizon. Now, this is probably a committee that doesn't think irresponsibly, but I occasionally do hear from some factions of the Tea Party and some libertarian-minded folks that we could just default. Who cares? Stick it to China. Well, Argentina tried that. And 10 years ago when it tried that, it's been chased by creditors ever since. It's been basically blocked out of most world trade agreements. Its economy is a disaster, and they've nationalized their equivalent of 401ks, replacing people's hard-earned savings with government bonds that are worthless, or will be soon. So this is not an option, no matter who claims it is. This is totally irresponsible even to think for a moment about. Let me also emphasize that we all know that Washington will not tie its own hands. It won't. It never has. We had a fleeting moment with Speaker Gingrich and President Clinton. It was a fleeting moment because the problem is structural. Remember that exponential growth curve. That is a broken system. That is not a blip. And then if you go to the next page, if you're a fan of The Lord of the Rings like I am, maybe some aren't, but nevertheless, the problem here is concentrated power. And very simply, the concentration of the power of the debtor to write his own credit limit. I mean, The debtor, of course, is the federal government. And so this is if you think about this, imagine if you went to a bank and had a loan request and said, you know, I'd like a revolving line of credit and I get to set whatever it's going to be at any point in time. That'd be a quick way to make that bank insolvent if it agreed, and that's what the people have done so far. What we've basically done, we've allowed that kind of agreement to exist in Washington. We have to stop it. It's not sustainable. I've got a 7-year-old, I've got a 9-year-old, they're going to be 8 and 10. Their lives are in jeopardy. If you have kids, your grandkids, their lives are in jeopardy. This is not something we can deal with without extraordinary efforts. So, what's the extraordinary effort? Article 5 famously gives Congress the ability to propose amendments, but it also gives states the ability to organize a convention for proposing amendments as well. We need to start using the state-originated process for no other reason that we know Congress will not do it. So, let's get to the meat and potatoes. The problem of Article 5 is that Patrick Henry had a point. Now, some of you are probably already aware that there were people who didn't support the ratification of the Constitution. They were known as the Anti-Federalists. They weren't chumps. They were led by the likes of Patrick Henry and George Mason. These were very serious patriots, and usually for really principled reasons. For example, George Mason, and I think also Patrick Henry, but definitely George Mason, opposed ratification in part because of the Slavery Compromise. So there was an opportunity to really debate the Constitution. And Patrick Henry said these errors cannot be fixed with Article 5 because it's a Rube Goldberg's machine. And let me walk you through, he didn't quite use the word Rube Goldberg's machine, but when there are only 13 states, his main argument for 6 hours on the floor during the ratification convention in Virginia is the errors in the Constitution cannot be fixed effectively from the states because if you walk through this Article 5 process, even with only 13 states, it cannot be done. Now, with 50 states, we really need to keep an eye on what Article 5 requires without a compact, without an agreement in advance like we're advancing today. It requires over 100 legislative acts. It requires those legislative acts that take place over 5 or more legislative sessions, both state and federal. You need 34 states to advance an application for proposing amendments. That takes a resolution passed by majorities in 34 states. You need Congress to respond to that resolution, that series of resolutions with a call. That takes a resolution as well. They have to pass that with simple majorities. Now, they're obligated to, but Congress never violates the Constitution, so we have nothing to worry about. Actually, we have a problem with Congress. Congress may not do that. But the point is it takes another set of legislation to get the call done. Assuming the convention is going to be organized, you need to have states send delegates. They have to pass laws to identify who those delegates are. So at least they have a quorum in a traditional sense. You need 26 more pieces of legislation. Then, assuming the convention meets and actually does something, proposes an amendment, it has to go back to Congress. Then Congress has to pass another resolution with simple majorities to refer it out for ratification. And then, after that's done, you have to get 38 states to either ratify it through conventions or by their legislatures. And mind you, if they have to do it through convention, many states don't have that law already laid out. So you've got another piece of legislation on top of the legislation that would happen at the convention ratifying it. Now, I don't say this because I oppose this process. I support this process. I was in the States supporting this process without a compact for 2 years. I banged my head against the wall of this process in 20 states, providing support, testimony for people like Representative Braddock and Representative Welch. And you know what? In 20 states, we only succeeded in 2. Now, we didn't have the grassroots networks that we currently see. That's true. But Ronald Reagan and Milton Friedman didn't succeed in the 80s and the 70s with a similar effort. They stopped short by 2 states. Now, as great as everyone involved in this movement is right now, we do not necessarily have the same degree of talent as Reagan, Friedman, and the equivalents on the left. We need to at least consider a different angle of attack, something that is simpler, easier, more plannable, more campaignable, if we really want to originate amendments that the states can only do because Congress won't. Here's how we can do it. We'll skip this page and come back to it in the interest of time. The compact approach to Article 5 collapses by using conditional enactments. I'm sure everyone here is familiar with conditional enactments. It's when a piece of legislation only goes live when something else happens. And they're used to trigger state legislation, even on federal legislation. So that the general case law, and it's in the FAQ, is overwhelming. I've never seen such unanimity in the law or sustained over as long a period of time. No one has ever said that you can't use conditional enactments in the way that we're proposing. But basically what you do to make the process simpler is you collapse those 100+ legislative acts into just 39. Now I say just 39, but you also have the advantage of making it possible to be in and out in one legislative session year. Now we're not gunning for that. We're hoping that we can get this done in 3 years. But in principle, by collapsing into a compact, by consolidating all this legislation into one bill that you pass once in each state, you can, in principle, get it done in 12 months. That is a logistical impossibility without a compact. And as I said from the beginning, if you think we've got a lot longer than 12 months to fix this debt problem, then you're really pretty much saying we're going over that cliff anyhow. I think we need a vehicle that can get this process done as quickly as possible. And as good as Article 5 is, I'd rather have it than not have it. We finally have a vehicle that can actually get it done in a time frame that we need for a balanced budget amendment, which is direly needed. So let me just walk you through it. What's in the compact before you? The references to A are the references to the article in the compact, so when I refer to a section, you could eventually go back and circle and see what it's all about. First of all, in the compact, we specify the amendment that's to be proposed. So there is a specific amendment idea, known political payload, that you can assess. You're deliberating right now. You are, in effect, being founding fathers and mothers, right as you sit at this table. The second thing it does is it creates a commission. This is as soon as 2 states join a compact, and this is common to many, many interstate compacts. As soon as 2 states join this compact, an organization is formed by the founding member states, we hope Georgia will be one of them, that will have the job of organizing the logistics for this whole approach, and also to provide a platform for lobbying in a unified way other states and Congress to get it done. In the compact is the Article 5 application. Now here's where we use our first significant conditional enactment. This application only goes live when 38 states join. The reason for that is that's the number you need for ratification. There's no reason to start this process unless you can get it finished. So the basic idea here is as soon as 38 states join the compact, it goes live, not sooner. Additionally, it contains all delegate appointments and instructions. So you don't have to go back to the states for any of that to be determined. It's already provided. And by the way, Representative Welch is responsible for some additions to that have already been made. Each state has authority to change those provisions to suit their own circumstances. The default represents Representative Welch and Representative Braddock's sense of what is politically desirable in Georgia right now. Additionally, the convention rules, the logistics, the parliamentary rules that actually are required to run the convention are specified, and delegates are required to vote them into place. So you don't have to have this sort of dark box that you don't know, this black box that you don't know anything's going to happen until you get there. You know in advance exactly how everything's going to be planned. To mollify those who fear the convention running away and doing crazy things, there's actual, in Article 8, a total prohibition on the convention doing anything other than an up or down vote on the particular amendment that it has. And there are a variety of kill switches that basically determine the whole thing to be null ab initio, meaning totally invalid from the beginning if anything else happens. And then finally, we've preloaded the ratification, again, using a conditional enactment. The ratification of the pre-designed amendment says this ratification only goes live if it's in fact approved by the convention and if in fact Congress refers it out for ratification by legislatures. There is absolutely no reason under current case law why that cannot be done. And so that is the compact. You pass that, you've gone through every stage in the states that would otherwise require at least 98 pieces of legislation. 38 states pass this bill, you're done. You can plan for that, you can campaign for that, you can message for that. You know who the political players are for that. The same is not true without a compact. Without a compact, you're not only throwing a Hail Mary pass, you're doing it blindfolded to a receiver who's doing a backflip. So what's the congressional component? The congressional component is another simple way of getting congressional buy-in. In order for this compact to work, we need an omnibus resolution that combines both stages that Congress has control over in one single enactment. It has both the call for the convention and the ratification referral. Again, using the magic of conditional enactments, and make sure that each one goes live at the right time. And so the call only will go live once 38 states join the compact. The ratification referral will only go live if the convention actually approves the amendment. But you can pass that at any time and once, and you're in and you're out, and you're done with Congress. Whereas without a compact, you have to go to Congress twice, both at the call stage and at the ratification referral stage. This is a simpler, easier way to get a targeted amendment that commands supermajority support done. If you go to the next page, just a few minor points, and we'll skip through this very quickly. We're almost done, I promise. And I know you've heard that from attorneys before. But the bottom line here is you have significantly reduced lobbying requirements. You have fully defined the process. You have fully defined the product. You can campaign it. You can message it. This is as usable now as a ballot measure is in the western states to achieve constitutional amendments. And we found out by polling 1,000 people that once you tell people all a compact is a more convenient way of getting things done and unifying the states behind something, if you ask them whether they'd like to use a compact for desired constitutional amendments, they favor it 2-1. So it's not that weird an idea, not to even ordinary folks. Next point that I want to make about the compact approach is we always are worried about Congress responding to efforts from the states to reform Congress. That makes sense. Why do we think Congress will ever tie its own hands? Even if they do, they'd probably find a way around it. Well, here's the simple fact. Congress has a strong litigation hand in the Article 5 process. Not that they should win, not that they would likely win, but because there is not yet completely clear Supreme Court precedent providing guidance at all levels of the Article 5 process, Congress is going to have a plausible litigation hand if they want to claim some degree of control over the process. Now, there's two ways you can approach that litigation hand. You can ignore it, hope that we draw the right courts doing the right things and achieve the best results, or we can actually try to co-opt and overcome. And what the compact does by having both of the congressional processes in one single resolution is it allows us to look for the hole in the line in Congress to pass something with simple majorities. And we know from past congressional balanced budget proposals, every serious balanced budget proposal has commanded simple majorities. They just never hit the 2/3 threshold. So we know these holes in the line do politically exist in Congress. So what this is an effort to settle in advance the political differences that will exist between the states and Congress from the strongest possible position that the states can possibly occupy by filling all voids, all gaps in the Article 5 process, and then basically saying, Congress, do the right thing, and implicitly, or else. And the or else is serious political punishment. If you think that in a year you got 38 states and American people behind this, Congress is going to say no to that? An institution versus an institution? Not if they want their jobs. Lastly, and we can just go to the questions on the specifics on this, I want to emphasize that we designed this compact, and when I say we, I mean many, many other people. We're going to have a complete list that we can distribute later. But when we designed this compact, we started with Phyllis Schlafly's famous 20 questions. The 20 questions of who's going, where's it going to be, how's it going to be run, what's going to be proposed, etc., that she used successfully to beat Ronald Reagan and Milton Friedman in 2 states in the 80s. She beat them with some help from other people, but nevertheless she beat them with those questions because there were not answers to those questions. We crafted this compact around specific answers to each and every one of those questions. Not only that, we engaged Andy Schlafly, Phyllis Schlafly's son, as a peer reviewer and a reviser to the compact, and engaged him for several months. And in fact, a number of the provisions in the compact have his fingerprints on it, and we can prove it by email, and frankly, we have now neutralized his opposition to this mode of attacking the Article 5 problem. The bottom line is we have a certain process. We have it known in advance. We have a certain political product. We have it known in advance. It can be planned. It can be messaged. It can be done in 12 months or less. And that's why I hope that this committee will support HB 794.
Thank you for that presentation. I'm looking at the bill itself. You have the constitutional amendment as set out as an article, but it's unnumbered, correct?
That's correct.
It's Article 2, top of page 2, I'm sorry, page 3. The one thing I asked Mr. Welch about, and this I guess goes to the issue about compact, the ability to bind a legislative body to a contractual obligation passes adjournment. How do we do that? I mean, how can I bind what may be the legislature 3 sessions from now will say as to what we're wanting to be done by them today?
Well, Mr. Chairman, that's a very important question. In fact, it's one of the questions that was so important that we marshaled our team of experts, historical and legal and jurists, to answer in the fact. And here's how it works. It's well established in interstate compact law that an interstate compact is a contract. And as a contract, it is actually enforced and guaranteed by the U.S. Constitution's Contracts Clause, which bars states from impairing contracts. And so as a result of barring states from impairing contracts, once you form this compact, it does entrench itself just like any other contract. And in fact, it is an exception to the rule against entrenchment. Now, this has actually been the case law from the U.S. Supreme Court for over 100 years. It's even followed in the Ninth Circuit. So the real question is, have we gone too far? Have we entrenched too much? Have we delegated away too much sovereign power? Because there is a risk if you do that. If you get, for example, you may be familiar with annexation agreements in the development context, where developers try to get a guarantee that there won't be any eminent domain or that zoning will be used in a certain way. Courts in a lot of states have struck those down as being too much of a delegation of power, too much of an effort to contract away your sovereign powers. The test courts use is this a substantial invasion or impairment of your police powers? Is it permanent? And generally, if it's not permanent, if it's temporary, if it's a small smidgen of entrenchment, the courts will in fact allow it. In fact, Georgia is a member of the Interstate Compact on Insurance, and it has, in fact, entrenchment provisions. Once the state of Georgia now approves a certain insurance products, that approval cannot be withdrawn without following a very strict process that requires an interstate commission to approve a change. And in fact, you'll find that in most interstate compacts you have similar non-withdrawal entrenchment provisions, and they have been litigated. In the one case we cite in our FAQ in the Ninth Circuit, they were upheld. And so you're probably going to ask, well, how extensive is this entrenchment? All that the compact does, and by the way, this was a suggestion by Andy Schlafly, and this was very important to neutralizing ill forum opposition, if that matters. But what entrenching the compact does is it makes sure that the restrictions on the process that keep it laser focused will not be violated as a matter of federal constitutional law. Because if the states tried to do something differently than they agreed to in terms of voting up or down this amendment, it would violate the Contracts Clause of the United States Constitution. So it adds a layer of protection and a layer of locking in the targeting of this process that is not found if you just relied on state law or federal law alone. It's actually locked down as a matter of constitutional law, at least from the states deviating from it. And that was very important to Andy Schlafly with regard to the various prohibitions on a runaway convention. Now keep in mind that the entrenchment is very temporary. It will not last longer than 7 years, and it could last as short as 60 days. And that's because of the termination clause at the very end of the compact. It basically, the entrenchment only starts once 38 states join the compact. Up to that point, you can withdraw freely. And as soon as the BBA is ratified, the whole compact is terminated, it goes away, and that could take place as soon as 60 days later. At worst, the sunset provision makes sure the whole compact goes away in 7 years. And we think that if a court were to look at this and say, well, is that too much of a delegation of authority? The fact that it only arises when 38 states join, the fact that it does go away either as soon as 60 days or is in no longer than 7 years, this puts it squarely in a position where you can argue that this is not a substantial impairment of the sovereign power of the state.
All right. Questions? Anybody have questions? I've got one button pushed over here. Who is that? Maybe a mistake. Yes, sir.
Hi. I'm assuming all of that was simply to say you want to make it easier to change the Constitution. Is that a fair statement?
Mr. Chairman, Representative, members of the committee, absolutely.
Okay. And how many times has the Constitution been changed? About 26?
27, most recently, something that was hanging out there from the Bill of Rights era was ratified 202 years later.
So there's a process that is already in place that apparently has been successful 27 times. Is that correct?
It is correct. However, if I may, just caveat that, not since the original Bill of Rights has there been an amendment to restrict the power of Washington.
Well, but still, the point is the process is in place to change the Constitution. That is what your purpose is to make it easier to change the Constitution. what is it, you know, I heard all that you just said, but what is it that would be, if I had to go back to my constituents and tell my constituents that I want to make it easier to change the Constitution that has protected them pretty, you know, good for a long period of time, what would be my argument to do that?
Mr. Chairman, members of the committee, well, it depends on your constituents. If they're constitutionalists, and I assume that some might be, it would be important to emphasize that the founders themselves repeatedly promised, that the process for amending the Constitution would be easy. And I really quote, easy. If you look at the fact, everyone who supported the ratification of the Constitution promised to the American people that the amendment process would be easy, quote unquote. And so, first of all, the founders recognized there were extreme errors in the Constitution, but they had to get something done because they were looking at the looming forces of Britain and France. One of the most obvious looming horrific errors was the compromise on slavery, and the founders genuinely hoped that that would have been eradicated through an amendment process that they promised would be easy, so they could get through the initial stage of overcoming the empires that faced them in the world and have unity. So I would emphasize that that nothing's perfect. The founders intended for the Constitution to be amended. It has been amended 27 times. The problem is structurally getting Congress to amend it now in ways that limit its own power, and particularly their use of debt. Congress has shown no willingness, whether it's been Republican-controlled, whether it's been Democrat-controlled, to hit the two-thirds threshold needed to actually limit their use of debt. We have no other choice, as I've shown you with the data. That data compels us to take quick action. Now, we're not saying that the Constitution would be amended as an everyday process. 38 states and, you know, simple majorities of each House of Congress, that's not easy. It's easier. It's easier. We're not quite yet fulfilling the founders' promise, but it is plausible. And there's no question in committees like this, there's serious deliberation going on. Right now, the question you're asking is a question like would have been asked at the Philadelphia Convention. And that gives the states a degree of empowerment that I think in and of itself fundamentally shifts the relationship with Washington, makes you more relevant. So I would tell your constituents, do you want to be more relevant to Washington? And then one more thing, this is not a left-right thing. On Compact for America, Inc.'s Board of Advisory Council, Professor Lawrence Lessig, friends with a number of progressive Supreme Court justices, known to be rather progressive himself, he supports any angle of attack on amendments. Now, obviously for different reasons than I do, for different objectives. But I think both progressives and conservatives, both constitutionalists and those who view constitutions as more like a mission statement, I think that we can all agree that it's important to have avenues of reform. And avenues of reform that originate with the states and the people because they're closer to the people.
All right, let's move on, go shorter time. Mr. Fleming, do you have a question? Pull your, Mr. Welch does. Well, pull your mic over, Mr. Welch.
Yes, sir. Can I get that the red easy button? Seems like what we're trying to put here. I think Representative Bruce is right to raise a concern, and that you want a deliberative process whenever you're talking about the Constitution, the bedrock document that holds this society, a very unique society, together. But let me make sure we're clear. This compact follows exactly what's contemplated in Article 5. It just streamlines the process into one agreement by 38 states. You got to have all 38. That in itself, while maybe faster than the way Nick explained it to you just a minute ago, if you did it the more traditional, let's pass individually states multiple pieces of legislation, this just streamlines it down. I think that's good. My question, I think I want to pose to this body is, if you make it too difficult, where does that lead you? And we already have answered that question. If it's so difficult that you cannot amend this Constitution, we fought a civil war over 3/5 of a man. Where are we headed now with the finances of this country and the finances of our children in the future? Where are we headed? It may not be a civil war, but it may be indebtedness that we can never get out of. Both are awful, awful outcomes. And bear in mind that it was attempted to amend the Constitution prior to the Civil War by numerous states. I think the approaching just less than a few states were needed to actually amend the Constitution by state convention and by congressional enactment. Both avenues were attempted to avert the Civil War. Both failed. So I'm just deeply concerned for the future of our country financially, that I don't want all of that history to be lost because we financially put ourselves back into servitude that should be gone from this country forever.
This came out of Mr. Fleming's subcommittee with a favorable recommendation, and we're going to begin a process Thursday on hearings of the bill. So I want to thank you for taking the time to come today and be with us and give us your insight about it. And we have your literature, and hopefully everybody will take the time to read it too.
Thank you, Mr.
very
Chairman.
much. Thank you, Ms. Braddock. Let me pause for a moment to acknowledge and thank a very dear friend of mine being here today, Judge Tom Campbell, who is representing our judiciary and member of the Fulton Superior Court. So thank you for being with us today, Judge Campbell. Any other judges with us today or in the audience? Anybody from the district attorney's office? Elected officials? If not, we'll proceed with the rest of our hearing. I believe we have, I'm going to take next Senate Bill 125. You have in your folders the Senate bill. And Senator, we're always pleased to have you with us, Senator Stone.
I want to thank the chairman and the committee for allowing us to go forward on this and all the cooperation we've gotten over the last 7 months.
Yes, sir. Why don't you present to us the reasoning behind Senate Bill 125? Why don't you pull that mic around too? Pull the mic around for us, if you would. That'd be good.
All right, what SB 125 does is codify the common law as it deals with premises liability in the case of trespasser. Currently, Georgia does not obligate a landowner to trespassers except to avoid willful and wanton behavior. There's one exception to that, and that is the attractive nuisance doctrine, which applies to minors. Now, most of y'all may remember this was presented last session. The chairman quite rightly pulled it so that we could perfect the legislation. Since then, we've had input from Georgia State personnel, the law school there, and what we've done, the basic change from last session is that in the bill as it appeared last session, we stated the elements of the attractive nuisance doctrine. In this bill, we have taken our attempt to restate the elements out and just indicated that nothing in this legislation will change the common law as it applies to the doctrine of attractive nuisance. Now, this is a necessary bill. It sort of heads off at the pass any effort to expand rights of trespassers against landowners, and it has the reason for it is there have been some academic efforts at quite a high level. The restatement of law, the third restatement of law by the American Law Institute suggests that there should be an expansion. And this is a policy decision that we do not want that done in Georgia, and it has garnered support across wide segments of industry, the National Federation of Independent Businesses, the Georgia Chamber of Commerce, Georgia Farm Bureau, several with Georgia Railroad Association, Georgia EMCs, Georgia Apartment Association, and on. We believe the legislation has been perfected with all the thought that's gone into it since it was first introduced last session. And with that, I'll be happy to attempt to answer any questions.
Thanks, Senator. Any questions of members of the committee regarding Senate Bill 125? Let me follow up with what was comments by Senator Stone, and as he mentioned from last session when the bill came to us from the Senate, I looked at it, several of us looked at it. We had some concerns relative to what we were trying to do in codifying the duties of a trespasser, because we really don't have in the statutory law provisions addressing what are those duties. It's been basically through common law and therefore by case law that we have evolved to what we do have as a understanding, we'll call it, of whether a duty is owed to someone who is trespassing your property. As lawyers know, you got three classifications. You've got the invitee, you have the licensee, and you have a trespasser.
I might add, Mr. Chairman, that the first two categories you indicated have already been addressed by codification.
True, they have. That's right. And so we don't have trespass, but we've always had a good body of law by case law which defined what you would have a responsible duty, and most of it addresses what you say. You don't have a general duty to a person trespassing your property, except you cannot willfully do harm to them. And then you have the next classification, which is to the persons who are minors, and by their age and demeanor, whether they have knowledge or ability to avoid what may be attractive nuisance. And the thing to think of attractive nuisance when you have a swimming pool that's unfenced, you have a well that's uncapped. Those things may be recognized as attractive nuisance. So there is duty as expressed by case law. So when we did not have that looked at as a part of the policy of this bill, statement-wise, we asked some people who were academia to look at it, because I was concerned what effect it may have upon our long-standing and well-reasoned case law in Georgia. And one of the things they come up with, I think it was a reasonable thing to do, is look on page 2 under paragraph C, and it speaks of the recognition, we'll call it, that Georgia common law as it exists and is applied to the doctrine of attractive nuisance in effect as of January 1, 2014 shall not be construed to be altered by this code section. So the body of law that we have will stand. And we felt that was an appropriate pronouncement by the legislature to go with our codification of what is the definition of the trespasser. So what we have now is that language under section A and B is to the possessor of the land. There's not a duty owed to a true trespasser, but we do recognize those exceptions that we're talking about with regards to attractive nuisance. I'm going to say something.
That's correct, Mr. Chairman. I would also like to point out that involved in the evolution of this bill has been Georgia Trial Lawyers Association, and in my last conversations with them, they were on board. I'd also like to point out that every state bordering Georgia has similar legislation, so we're not alone in this, and I would urge that it be passed.
I have some questions, Senator. I believe number 13. Is that Mr. Powell? Yes, sir.
Appreciate you bringing the bill. I thought that the job of the restatement people was to restate the existing status of the law based on surveying what various states were doing. When did this group decide that they were going to make policy?
Well, you know, I'm sure in some ways they try to push their own views through, but I don't know what was going on within those inner circles, but the but you have to take these types of restatement with a certain scrutiny and care, because if you don't, then what had not actually been the law in the majority of jurisdictions can suddenly start becoming the law. And I think they got ahead of themselves. Maybe the academics within the circle did that. I can't say.
And Mr. Jacobs, please.
Thank you, Mr. Chairman. When we had this bill before us last year, well, and of course now I'm looking at the wrong bill. When we had this bill before us last year, I believe the date in line 26 was January 1st, 2013, a year ago. I just wanted to confirm. I mean, and I presume the answer is no, but I might as well ask the question. I mean, have there been any developments in the attractive nuisance
Not to my
case law
knowledge,
in Georgia in the past year?
Representative, but I cannot say with 100% certainty. I think had there been some, I would have been notified by all the people watching this.
Okay, and there are some wise heads shaking, going
Right.
no in the back, so we'll take that as a no, unless they hear otherwise. Thank you, Mr. Senator.
Do we have any further questions of Senator Stone? Yes, sir, Mr. Mabra.
Thank you, Mr. Chairman. Quick question. What was the purpose behind codifying the case law and giving the definition? Like, if things have been going pretty good, is it just something we just need to catch up on, or were there some cases that came out? What was the reason?
Well, the fear is that what was being advocated in the restatement third would be planted in Georgia, and we're not at that point where we want to expose landowners to enhanced liabilities. We like the law as it is, and we want to keep it that way.
Okay, restatement of tort.
Right.
Anything further from members of the committee? Well, thank you for your
Thank
presentation,
you, Mr.
Senator
Chairman.
Stone. And I want to check to see if there's anyone else in the audience who wishes to address the committee on Senate Bill 125. I see no one else, and with that, we'll close all further public comment. The bill is now in the breast of the committee. Do we have a motion? We have a motion to do pass by Judge Caldwell. It was seconded by Mr. Jacobs, was it? All right. Motion made and second. Do we have any discussion on the motion? Sorry. It is committee substitute. Yep, sorry. We're dealing with the committee substitute, which is LC 295773 ERS. No further discussion on the motion. We'll take a vote. All those in favor of the motion do pass, signify by saying aye. Aye. Opposed, like sign. Well, very well. You got
Mr. Chairman,
bill we'll take forward to rules.
thank you, and Representative Tom Weldon will be carrying it. I'm just reminding you. Thank you. Yeah, wanted to stick with my commitment.
Yeah, where is that? I can't find that bill in here. Did I pull it out? I don't see it in my folder. We'll get one. Excuse me just a second. As they say on TV, one moment, please.
It's across the surface, it's behind that one, but you don't have the
I don't have the other one. I don't have the affidavit, though. That's what I'll do next. Thank you. Got it. All right. While the crowd leaves the room, leave us to our real business now. Next bill we will consider will be House Bill 842, of which I am the author, and this is LC 295708. And Mr. Fleming, as Vice Chair, I'll ask you to chair during this. What'd you want?
I was just communicating with my Mr. Chairman. Sorry about that.
Okay. We'll get Mr. Fleming to chair of the committee for this bill. You can do it from there if you'd like, or you can come up here. I'll turn your mic on. One thing I think you remember, give you a chance to. That's good. We're on House Bill 842, and LC number is 295708.
295708.
Yes, sir.
Okay, Mr. Chairman, this is your bill, so you want to start us off by explaining to the committee?
Thank you. I will. Before you is a bill that was brought to my attention through Justice Carol Hunstein, and it's a matter addresses the difficulty that the Supreme Court was experiencing regarding those who are in a indigent capacity being able to bring filings to the court on appeals because the necessary application for indigency required an affidavit to be signed by the person, which requires a notary, to be their official signing with the indigent. And the practical matter is, in many of these cases, you have people who are in corrections institutions who are unable to obtain a notary for that purpose. And so the desire was to modify the provision of the law to allow a person to file without the application if the applicant or appellant is incarcerated at the time of filing. So the only change was if this person is incarcerated, then there is not going to be the need that the applicant file their application of indigency. It would be obvious they're indigent, they're in prison in most cases. So she felt it would be certainly in the interest of justice to, if there's a need to have these appeals coming to the court, for the court to do so without dismissing or discharging failure of their duties because there's not a affidavit accompanying their appeals. That is the basis of the legislation, Mr. Chairman.
Thank you, Mr. Chairman. Anyone else here today that would like to testify on House Bill 842? Hearing none, then we'll bring the bill back to the committee. Are there anyone with the committee that have any comments regarding the bill before the motion?
Have a motion. Have a motion at appropriate time.
Mr. Chairman, Roll.
I move do pass.
It is moved to pass by Chairman Rowland, second by Representative Davis. Any discussion on that? Hearing none, all those in favor say aye.
Aye.
Any opposed? Bill passed.
Thank you. Mr. Chairman, you might want to stay as chair. The next bill we have is going to be House Bill 829, which I am also the primary sponsor. This is LC 295786. Yes, sir. Let me proceed presenting it, Mr. Chairman. First of all, to give you a little history and to explain the purpose behind this, several years back, I have worked for quite some time to try and streamline, and I'll say legalize, you might call it, the program we have in Georgia, we'll call it, with regards to private process service. The difficulty has been, as you, a lawyer, and myself, many times we have a need to obtain the services of process server. There has been a limitation where they can do their service, which courts they may be authorized to perform that service. And so we tried and have enacted a law under the Civil Practice Act. It's known as 9-11-4.1. Section 4 deals with what is the recognition of the forms of service to be made of process and summons in Georgia. 4.1 is a section that recognizes and authorizes there be private process servers with the need to have them to go through and become certified, and that certification was undertaken and handled by Administrative Office of the Courts. You have a letter in your file dated January 27th, 2004, which I think gives a good history. This was given to us by Paul Tamaroff, who is the president of the Georgia Association of Professional Process Servers, and with whom I worked and have worked for several years with regards to this matter of legislation. The benefit of it is, I think the great benefit is that people who are going to be serving process are going to be going through a need of having training. That training is a very extensive 12-hour course before they get certified. They have to stand a test. The test is administered by the Administrative Office of the Courts. The state does not incur any extra expense. There is a charge for the services that are presented through the training process as well as the testing process that is paid by the applicants. They have had, I think it says here, 127 process servers have become certified. Now, ladies and gentlemen, I know in my practice over the years, one of the hazards we've had in serving as attorneys and filing lawsuits and responding to lawsuits is a question of whether there has been met the requirements of actual service required by law. I've had papers left with neighbors. I've had have them put under the door, which requires personal service. I mean, going for a length of things that have been problem-wise, and so you do run into this difficulty from time to time in practice of law. And so what they're doing is, in this instance, is being sure private process servers know what the actual requirements of law for service of process and summons would be in Georgia. This is an additional form and right of service beyond what you have, which is normally the sheriff's office or the marshal's office. It is strictly optional and voluntary for a lawyer and his clients to use a private process server. But speaking personally, most times when I now have need for service, I use a private process server for very clear reason that I know what's done is being done correctly. So when we passed the law back in 2010, actually passed in 2009, became effective in 2010, at the behest of the sheriffs, wanted to see how this would all work through. There was a sunset provision, and the bill you have before you addresses that sunset and extends it. The sunset provision was July 1, 2015, which we will be approaching in a little over another year. I felt as a preemptive change that we would this year look at it. I think there's good cause to continue the law. Let's continue it under the sunset, but change the date to July 1, 2020, moving up an additional 5 years so we can further see how this is operating and if it's something we want to permanently establish. The second thing I might add is the courts have become, I think, embraced the use of the private process servers who have gone through certification. They are being recognized by the courts, where in the past some courts would not do so. As you recall, in most cases where we wanted to use a private process server, you had to file a motion. You had to sometimes go to a hearing. You then also had to prepare an order, having the person authorized for that one-time appointment. This now is saying set up the person where they're not needing to have the involvement of the court on a case-by-case basis. So I would encourage to the committee the consideration for extending the deadline.
Thank you, Mr. Chairman. Any questions of the chairman?
I see a light blinking, number 12.
Yes, Mr. Chairman. Given that this sunset was originally an accommodation for the sheriffs, I suppose I should then pose the question, do we still want to accommodate the sheriffs?
Well, I guess I've got one issue already percolating with the sheriff. I just was trying to limit how many battles I wanted to pull. I don't want to start singing the song I took on the law and the law won.
Today, and somebody posed a question for me, which I did not have an answer, and nor did I have time to talk with you beforehand. If I understand it correctly, just to pose my question, there are three types of process servers. There's a case by case, where any judge who has a case before him can appoint by application someone to serve, and quite often that's when you're having difficulty getting service.
Yes.
Of course, then always the sheriff's department can serve.
Correct.
Then there is a permanent process server, but they can be appointed by a Superior Court judge, but that is just for his judicial district.
That's correct.
Well, it'd be Fulton County, it'd be just in Fulton County, or DeKalb County, just in DeKalb County. But the third one is what we're dealing with here, and that is what we call a certified process server, and that's this process which is laid out a few years ago in the code for someone to be certified potentially to serve statewide. Is that right?
The full state, yeah.
Right.
Ability.
And this portion that was somewhat referenced to by Chairman Jacobs about the sheriffs there was also a provision in there that gave the sheriffs the ability to say, well, I don't know this fellow, I don't like him, and therefore in my county I'm not going to allow him to serve. Is that correct?
Correct. That's still in the law.
And this does not affect that?
No, sir, it does not.
But the question that was posed to me was this, that there is currently, I was told, and I don't know, this first I've heard, there's a lawsuit going on in the metro counties against the sheriffs in some form or fashion, potentially for exercising that option. Is that?
I think, yeah, I know of the lawsuit being filed. I'm not even sure who the parties are, except I think the association of the process servers or individuals in that association have sued the Sheriff's Association. The basis of the lawsuit, as I understand, is that there has been an arbitrary position taken by the Sheriff's Association to deny anyone who has become certified the ability to make service anywhere in all the counties. And it's sort of like I'll say a compact. We heard talk about that. There's a compact between the sheriffs, and that came to light, Mr. Fleming, about 3, 4, well, back when this law was passed the next year. I became aware of an internet posting on the sheriff's website which said, in fact, no, do not allow any of these people to come in any of your counties, any of your jurisdictions. I think, you know, I'm sure, resurrect that email, but it really incensed me as a legislator who fought for this issue, and we were giving the sheriffs this right if they felt there was someone who they believe was improper in their conduct or something in their county, to not be able to do service there. They've taken to a broader step. They contend, well, it's not a broader step, is what the statute allows, but in the negotiations of the provision to put it in there, the understanding would be this would give you that final oversight to whoever is certified, whether they're appropriate to be allowed to come into your county. And they took it to the farthest end they could and just said, all of you deny all of them. And that's what I think is the stemming basis of this lawsuit. Anything else, Mr.
Wells?
And as I read the statutory provision, if we don't extend this deadline, then anyone who's been certified as a statewide process server pursuant to this code section, their certification would expire. It's a 3-year certification, so it would expire. So all those people that have, undertaken the task, paid the money, gone through 12 hours of training, etc., and have been doing this for, a number of years, if we don't extend it, then their license to do it will expire, and you'll have all 100 and some odd that will no longer be permitted to do
like $500 a head to do it, and they go through periodic, updating, retraining, you might call it, which we do as lawyers. Continuing education, we'll call it. They do that as a part of their programs.
Any other questions of the presenter from Bill? All right, we'll turn to the audience. Is there anyone else who wants to testify, or members of the committee wants to testify regarding the bill in front of us, House Bill 829? is no one, the bill is now back with the committee. Any other questions of the presenter before we entertain possible motions? Hearing none, is there a motion on the bill? Mr. Mabry moves that we do pass, seconded by Mr. Jacobs. Any discussion? All those in favor say aye.
Aye.
Any opposed? Okay. Bill carries.
Thank you, Mr. Chairman. Back to me as the committee chair. Is there anything else to come before the committee today? If not, we will stand adjourned. I hope everybody has safe travels back to their home or to their hotel room. Thank you.